All rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. Good morning. We're here today. Our case number 1CACV150054, Keg Restaurants, Arizona versus William Jones. Each side will have 20 minutes for argument, and appellants will be responsible for reserving any time that you'd like to reserve. These proceedings are being both audio and video recorded, so we'd ask that you identify yourself and your client when you approach the podium for the first time. We have read the briefs. We're familiar with the facts, we think. We've conferenced this matter, and with that, we look forward to your argument.
Good morning, Your Honors. May it please the Court. My name is Jad Masso, and I represent Keg Restaurants Limited, which the parties have been referring to on appeal as Keg Canada. Just as a matter of housekeeping, I'd like to plan on reserving 5 minutes of my time for rebuttal. The jury's verdicts against Keg Canada in this case cannot be reconciled with either the law or the facts presented at trial. And the entire judgment of the trial court must be reversed for at least two reasons. First, because the jury was given legally flawed instructions on two issues: liability for breach of the agency letters and on modification of contracts. Secondly, but more importantly, as a matter of law, there was no basis for liability against Keg Canada, the corporate parent of the parties who actually contracted with TOVK in this case.
Counsel, as we begin, so we're clear, you don't have an objection to the alter ego instruction that was provided?
We do. Oh, to the alter ego instruction? No, sir, we do not.
Okay.
As far as the two theories of liability that were presented, neither is supportable, and I'll address both. First, the two theories that were presented, of course, were alter ego liability, a theory of vicarious liability, and then direct liability, assuming that Keg Canada was, in fact, a party to these contracts. The verdict that the jury gave us actually demonstrates that alter ego was not the basis on which the jury found Keg Canada liable. Alter ego is a theory of vicarious liability, and as the trial court instructed, it is, in essence, a means of holding a parent company, in this case, liable for the wrongdoing of a subsidiary. The jury was instructed to consider the liability or the potential liability of each defendant separately and independently, and was asked to check a box on the verdict form for each defendant that they found liable. The jury checked only one box. They checked only Keg Canada as being liable.
Well, doesn't that make sense, though? Because if they properly apply the alter ego instruction, wouldn't that read, a jury, if they found liability that Keg Limited or Keg Canada is responsible?
Not in this case, Your Honor. Not with the instructions the jury was given here.
And why so?
Because the jury was instructed to look at each defendant's liability separately first. They were instructed to look to see, and taking the sublease is perhaps the easiest example, which of these Keg entities was liable on the sublease. They checked only Keg Canada. They did not check Keg Arizona, which was the sublessor, for example. So if Keg Canada, if we're looking to see if the alter ego liability theory could have applied, if we're looking to see that Keg Canada is vicariously liable for something, then what are they vicariously liable for? The jury found that Keg Arizona and all of the other Keg entities complied with the lease if they were in fact parties.
But if there is such confusion, I think that there would be grounds in this record to think that there's confusion among the various entities. Why couldn't the jury believe, following the instruction, that the Keg Limited is acting through its various subsidiaries, so it would likely hold Keg Limited liable rather than any of its subsidiaries who were just instrumentalities, so it looks like to me.
Well, I think what we have to look at is in particular the way the jury was instructed. They had to look at each of these entities and determine whether they were liable. It's impossible to see how Keg Canada could be liable for the actions of Keg Arizona if Keg Arizona is innocent. They had to have checked two boxes to have found vicarious liability. They have to be vicariously liable for something, for someone else's wrongdoing.
Well, I guess that's my question. Are they vicariously liable, or are they actually liable because they're actually doing the act and using the various forms of Keg Arizona and Keg franchise and all the other kegs as just mere instrumentalities?
Alter ego is a theory of vicarious liability. It is always going to be liability for someone else's actions. What I think Your Honor may be alluding to or may be thinking about is the Gatecliff theory that TOVK has presented for the first time on appeal. This third lane of possible direct liability, where it's, I think they called it direct involvement liability in the Gatecliff case. In that case, there were three theories: direct liability as a party to the contract, alter ego, or this direct involvement theory, which doesn't apply here for a variety of reasons, not the least of which it wasn't asserted at trial. But when we're talking about alter ego, it is vicarious liability. That's how the Arizona Supreme Court has defined it, and the courts of every other state as well. It's always liability of one person for the actions of another.
So, counsel, what you're telling us is that in order to hold Keg Canada liable, they would have had to have basically drawn us a roadmap. They would have had to have said, if you're going under the agency, you're going to have to go through Keg US, and then you're going to have to go up and come into Keg Canada, if that's what you're ultimately going to find.
They would have had to check two boxes.
But if there are multiple counts, then did they had an instruction as to each count?
That's
and as
right.
to each count, they had a series of boxes.
For each count, they were given all of the Keg entities options as liability.
And they would have had to have done that roadmap. They would have had to have taken you through Keg Finance or through Keg Limited or through Keg whatever, up into then Keg Canada.
They would have had to check a box for somebody that was liable for the wrongdoing and somebody who is liable for that liability.
Thank you.
The jury demonstrated to us that alter ego was not their theory. That was not the basis. Therefore, we have to look at the direct bases for liability. In this case, TOVK's theory was that Keg Canada was a party to all of these contracts, and they reiterate that in their brief. When we look at those particular contracts, however, we can see that there simply is no evidence to support a finding of liability directly against Keg Canada as a party to the contracts. Sublease, again, being a glaring example. This is a sublease of a lease that is held by Keg Arizona.
And who are the officers of Keg Arizona?
Who were the officers?
Yeah.
There were some shared officers.
And, so how is someone like TVOK supposed to navigate all of this when they're dealing with the same people? And it seems like in the depositions, the officers often couldn't tell in various circumstances whom they acted on behalf of. And I believe one person said he wasn't sure who he worked for, but he worked for one of the kegs. So if the employees or the officers can't keep it straight, how can TVOK keep it straight?
That was exactly TVOK's line at trial as the basis for their alter ego theory.
Not a bad line, counsel. How does anyone know if they don't know?
Well, they can look at the contracts for one thing. Under the sublease, for example, where it says that we're passing through the obligations of a lease, and the only person who has any rights under the lease are Keg Arizona. I mean, setting aside alter ego, there's the alter ego theory, which gets into abuse of the corporate form and fraud and all of that. We don't think there was sufficient evidence to support that finding either, but the verdict tells us that the jury didn't rely on that.
So if Keg Limited notices the default of the contract, then apparently they're the contracting party, right?
No.
I don't know of anybody that's not a contracting party that can declare a default for somebody else. So my reading is that Keg, and we've been referring to it as Keg Limited, not Keg Canada.
That's
so
all
I'm
right.
trying to keep that straight. But if Keg Canada, and I want to say Henderson, but I don't know that that's the case, sends out the notice and says, hey, man, you're in default. You've breached the construction contract. At a time, by the way, when Keg Limited, Keg Canada was the agency for construction, I think, which I found interesting. If that is sent out, then how can you not assume that that's the entity that is controlling the contract, party of the contract?
TOVK could have asserted that this notice of default isn't valid because it's not coming from the other party to my contract.
So they'd have to worry about it. They could have ignored it. They didn't need to, for instance, they didn't need to freeze the escrow account because the people calling them and telling them that they were in default had no authority to do so.
Well, the existence of a default wouldn't matter. The party delivering the notice shouldn't matter. They're either in default or they aren't, and if they've been put on notice that they are in default, then that's the trigger.
But it does matter, I mean, is who they are in default to, and if a stranger can't say, oh, you're in default, it's going to come from the party. And what bothers me about this is the shared offices. It's almost like what hat they happen to be wearing at a point in time, and I find it very concerning.
There was never a question of whether the notice was valid. That was never an argument that TOVK made. That
We're talking about confusion. That's what we're talking about.
Confusion, I see, and we looked at all the cases, confusion would be something that would support their argument of alter ego. It would.
Isn't it evidence from which the jurors could conclude that Keg Canada is the party? If Keg Canada is sending out the notice, I guess just going to your point, why do you have to check more than one box? It seems at least that's evidence from which they could conclude the real party was, in fact, Keg Canada.
Not on the sublease, because there was all of the obligations. I mean, there weren't that many, but of all the obligations that were flowing through to TOVK, Keg Canada couldn't have done any of them. They didn't have a lease. Only Keg Arizona had the lease and could have only fulfilled those obligations. They never argued, for example, that the sublease was illusory or that there was a default in the sublease on our side simply because we never gave them the property. They certainly got the property and built on it for a while. And that was performed by Keg Arizona. It couldn't have been performed by anybody else.
The building was controlled by Keg Arizona. The construction was controlled by Keg Arizona under the agency, right?
No, Your Honor. Under the development agreement, TOVK had full responsibility for development and construction.
I think it was Keg US. I think I spoke improperly. Counselor, here's my question for you. If I get a letter on Keg Limited letterhead that has a signature line from Keg US and the CEO of you spin the dial and you pick a name, is signing it someone who is not the person I would be expecting to hear from in Keg Limited or from Keg US, which, the signature line and the letterhead, but the issue is as to Keg Finance. Mm-hmm. Okay? Who am I to assume they're speaking on behalf of?
The determination is made by the contract itself and who is performing under the contract. I keep going back to the sublease, but no one else could perform. It doesn't matter what Keg Canada says or does because only Keg Arizona can give them what they're entitled to.
It seems like a shell game in effect of the same people are acting. It's just under the claim they decide to act, and they've gotten so good at it, they've confused themselves.
Again, I think confusion at most would go toward their argument of alter ego liability, that it doesn't change the fact that it's got to be vicarious for someone else. And if the jury has already told us, and this hasn't been appealed either, the jury has already told us that no one else is liable, no one else did any wrongdoing, then we have to interpret the verdict to mean that they relied on a direct liability theory. We can look at other things to determine whether there was a basis for direct liability, like who has the obligations and who performed. But there is no basis to look at this verdict and say, oh, it was alter ego liability, and so we can go off of that.
Counsel, I don't think I've ever seen a case where oral argument could be more helpful to this panel in regard to the mechanism of how this occurred. So the questions we have for you are questions that are based in the time we've spent going through these things. So please recognize that what we're asking you is questions we're very concerned about based upon the different documents and the different people signing and the different indicia that we draw from that.
I understand.
Thank you.
I understand. Thank you. With just a minute or so that I have left before I reserve some time, I do want to speak briefly about the liability question and the instruction on the agency letters. The concern with that is that it gave two bases for liability. This was a breach of contract claim. However, the instruction gave the option of finding violation for an express term of the contract or for breach of a fiduciary duty. The instruction itself informed the jury that agents owe their principles of fiduciary duty and that the duty requires an agent to work with reasonable care and skill. Didn't limit reasonable care and skill to a violation of the contract. It didn't limit reasonable care and skill to the violation of an express term of the contract. So in this case, the jury instruction was erroneous because it left wide open a claim that the trial court had already disposed of on summary judgment months prior. With that, Your Honor, unless there are any more questions at this time, I'll reserve my last 5 minutes.
Thank you.
Good morning, Your Honors. Kelly Chiviansky on behalf of the Appellees, Will Jones, Fabienne Jones, Tucson Oro Valley Keg, and OVM Kegland, which I'll refer to collectively as the Jones parties. Now, the verdicts that are being appealed followed 3 years of litigation and a 9-day jury trial. So despite Keg Canada's arguments to the contrary, we do think that it's important to start by addressing the extent to which Keg Canada preserved below the issues it asked this court to address. The Keg party's arguments below limit the scope of this court's review in 4 respects. First, the Keg parties never argued below that the jury must find a subsidiary liable before it can impose alter ego liability on a parent. Now, there were...
Did the form of the verdict form, I guess is getting the sentence out right, require the marking of 2 boxes?
It did not.
Did it say before you set this form aside, 2 boxes must be checked if you're going to find alter ego or vicarious liability?
It did not, Your Honor. In fact, there's no reference whatsoever as to alter ego or the form of the basis for liability. It just said we find this party liable to this party. And the jury instruction, there was a lot of reference to the jury was instructed that it had to find liability. The jury instruction on alter ego liability, which is reproduced at page 27 of the appendix, states, parent companies are generally not liable for the actions of their subsidiaries. However, a corporation is liable for the acts of its subsidiary under an alter ego theory when the individuality or separateness of the subsidiary corporation has ceased, and then it goes on further, but there's nothing in that that says you have to find the subsidiary liable before you can find the parent company liable.
How many days was this trial?
9 days.
And how much time, percentage-wise, would you say was spent on the lack of separateness testimony? What did the jury have in front of them on that issue is really my question.
Oh, on the separateness of the corporate form, the
or
facts?
Or the lack of separateness, or whatever you want to call it.
Well, the facts that were in the record as to all of the contracts at issue in the case on the separateness of the corporate form included that all subsidiaries, all of the entities were subsidiaries of Keg Canada. Keg Canada employees drafted and negotiated the terms of all of the agreements. There was express testimony on those points. All the communications related to these agreements came from Keg Canada employees. The letters were on Keg Canada letterhead. And specifically, there was statement about confusion as to whether the individuals were acting on behalf of Keg Canada. Neil McLean, who is the CFO of Keg Canada, was asked specifically in his testimony, and that testimony is reproduced at pages 186 and 187 of the Jones Party's appendix, as to whether the individuals involved were acting within the course and scope of their employment for Keg Canada, and he said that, yes, they were. Also,
beyond confusion, they were acting on behalf of Keg Canada when they were signing for Keg US or Keg Arizona or Keg whoever.
Correct. All of the actions that gave rise to this litigation and this dispute were actions that they took in the course and scope of their employment for KEG Canada. The KEG Canada employee, as you mentioned, James Henderson, the VP of Business Development, was the one who sent the notices of default and termination. There was testimony that the subsidiaries depended on KEG Canada for financing. Now, with respect to this...
Something popped in your mind. Was Henderson the one then that contacted Jones and advised him that it wasn't necessary to keep the escrow account sealed or something to that effect?
Actually, I'm not sure to which you're referring.
I did go then. Thank you. Thank you.
With respect to the sublease, KEG Canada has said in its briefing that the only fact there was the fact that KEG Canada's name was in the signature line, but actually, KEG Canada also asked the Jones parties to indemnify it for breaches of the sublease. In the indemnity agreement that KEG Canada drafted, KEG Canada identified itself as the party to both the lease and the sublease. So if KEG Canada can't keep straight whether it or KEG Arizona is the party to the lease or the sublease, certainly there was a sufficient basis for the jury to conclude that KEG Canada was the party to the sublease.
Does that then answer the alter ego confusion issue raised by counsel?
Well, I think there was sufficient basis in the record for both the direct liability for the jury to have found that KEG Canada was the party to the agreement. In addition, I think there was a sufficient basis in the record for the jury to find that KEG Canada was so heavily involved in all of these actions that it was in effect the alter ego of KEG Arizona. And on the alter ego liability, I do also want to make the point that the KEG parties never moved for judgment as a matter of law during trial on the sufficiency of the evidence of the alter ego liability. And in their Rule 59 motion for a new trial, they did not articulate any factual or legal basis for that argument. So with respect, I think that argument should be deemed waived in its entirety. At a minimum, the court's review should be limited to determining whether Judge Duncan committed a manifest abuse of discretion in denying the motion for a new trial on alter ego liability. Turning back to some of the bases for finding that KEG Canada was either directly liable or liable under an alter ego theory with respect to the various contracts, in addition to the facts that we've already discussed for the 2009 agency agreement, Bruce Sanford was a KEG Canada employee. He testified that he was a KEG Canada employee, and he was the designated agent to serve as the project manager. Also, in an email that the Director of Real Estate sent, which is reproduced at page 123 of the Jones Party's appendix, she stated it was agreed that KEG Canada, and of course she didn't use KEG Canada, she used KEG Limited, would act as the agent, and that was sent in 2010, so it was after the 2009 agency agreement. For the development agreement was amended 3 times in writing. All of those written amendments were on KEG Canada letterhead. As to the fraud or injustice element, and it can be fraud or injustice, I think at some points in KEG Canada's briefing it suggests that there has to be fraud. But again, the subsidiaries depended on KEG Canada for financing. It wasn't just one time, as KEG Canada says. It was KEG Canada who provided the funds necessary to develop the Oro Valley restaurant. KEG Canada also...
After post-breach?
It was post-breach.
So post-breach, KEG Canada provides the money to KEG...
It provided the money to KEG US, which in turn provided the money to KEG Arizona, which in turn paid the money to Vestar because it was funded through a bridge loan with Vestar. Pre-breach, there was testimony about how KEG Canada had to provide the financing to build a Texas restaurant, and in communications related to that, the Director of Real Estate said, referring to the U.S. entities, we have no money. Basically, we need to be able to get things worked out so that KEG Canada could provide us money because we have no money to build this restaurant. KEG Canada also paid the employees who were engaging in all of these actions.
Was there any question at trial about the underfunding of the subsidiaries? I understand the testimony you just talked about there became a time when money was tight in regard to the Texas issue. I understand that. Generally speaking, was there some question about underfunding? They shared apparently officers, corporate officers, spokespeople, whatever. They share all kinds of things. Was there ever a question about just simply being underfunded subsidiaries?
I cannot identify a specific portion in the testimony in which there was a specific discussion about whether they were undercapitalized. There was a lot of testimony about their inability to fund their own things, the development of their own restaurants, for example, and needing to go to KEG Canada to do it. There was testimony about their inability to fund the commitments that they had to build the restaurants in Texas and Arizona, for example.
So the recognized methodology was that if there was a KEG U.S. problem, involving money, the methodology was then you went to Canada and Canada brought the money down.
Correct.
And I make it sound like it's a map. I don't mean to do that. But it's in the flow of things from the principal, if you will, or the parent company to the subsidiaries. That was the gig.
Correct.
They weren't independently making these decisions or independently obtaining financing. They were going to KEG Canada, who then provided the funding necessary.
Correct, Your Honor.
All right.
Also, as to the fraud element, the KEG parties did induce the Jones parties to invest over $2.7 million toward creating this KEG franchise based on a promise that they would get a refund of that investment if the franchise did not go through. Now, that is documented twice, once in the development agreement and once in the First Amendment to the development agreement, specifically paragraph 8, which is reproduced at page 88 of the Jones party's appendix. And that provision states that even in the event of default, your money will be refunded if the franchise doesn't go through. And in the email communications that were exchanged in connection with preparing that agreement, KEG Canada's Director of Legal Services says, of course you'll get your money back if this doesn't go through. And then during trial, they sort of mocked the Jones parties for actually thinking that they would get their money back. So I think the jury certainly could have concluded that the KEG parties never intended to refund the money if things did not go through. Now, the second argument that KEG Canada makes as to its inability to be held liable for breach of the agreements relates to the agency agreement. They argue that the agency agreements were not valid contracts because they lack consideration and that there was insufficient evidence of breach of the agency agreements. Now, we believe those arguments were waived because they were first raised in a motion for a new trial, and again, there was no factual or legal basis articulated in that motion for those arguments. Even if they were not waived, at a minimum, KEG Canada has the burden of establishing that there's no substantial evidence in the record to support the jury's verdict as to either of those elements. On the consideration element, the jury was properly instructed that consideration can be either a detriment to a party or a benefit to a party. There's ample evidence in the record that KEG Canada benefited from these agreements. In fact, KEG Canada was the one who insisted on having this authority to serve as the project manager.
And what was the benefit?
Well, the benefits, KEG Canada was the one who guaranteed the construction, so it had an obligation to Vestar to make sure that the restaurant was in fact constructed and constructed properly. The restaurant had the KEG Canada name to it, or the KEG name. They were using KEG Canada's contractor, and KEG had a long-standing relationship with that contractor, so it had an interest in being the one to manage the relationship with the contractor, and it intended to operate the restaurant and actually is now operating the restaurant as a corporate store if the franchise fell through, so it being able to call the shots as to how the restaurant was constructed was a benefit to KEG Canada. As to the breach element, there was testimony from the Jones party's expert witness, Tom Caruso, as to how the KEG parties mismanaged the construction, or KEG Canada's employee, Bruce Sanford, primarily mismanaged the construction. That was an unrebutted testimony. And KEG Canada has taken the position that mismanagement of construction is not an actual breach of any express provision of the agency agreements. We disagree with that premise. In the agency agreement, it said that if you take on the construction, you are to do it as fully and effectively as could TOVK. The jury certainly could have concluded that by mismanaging the construction, it did not manage the project as fully and effectively as did TOVK.
Did KEG Canada want to manage the project rather than TVOK?
I believe KEG Canada did want. It certainly did undertake that responsibility. And in fact, there were times when Will Jones asked for information, said, hey, I'm looking at these invoices. Could I get some more information? And they said, back off. We know what we're doing. We've been working with this contractor for a long time. I mean, when Will did try to get involved, they discouraged that. They did want to take control.
Yes, I'm intrigued, having done some construction law. How does it take 13 months to get a pad, or 13 or more months, I guess, to get a pad permit?
That was exact. It should not have taken 13 months to get the permit.
Multiple times, it appears the pad permit's there, the building permit issues, or appears to issue, but then there are problems with the pad. What was all that about, and who was managing the project at that time?
That was, KEG Canada was managing the project, or more specifically, Bruce Sanford was managing the project at that time, and that was exactly the issue that Tom Caruso testified to. He said, I don't know, it should not have taken that long. There's no reason. It was a $546 permit. So it should not have taken this long, and that was a big part of the problem, and that delay is what caused them to be running up against the November 11th, 2009 deadline to complete construction under the lease with Vestar.
And because of the loss of the deadline, then Henderson, doesn't Henderson talk about the fact that they've not properly completed their construction responsibilities?
That was it. The KEG Canada ultimately relied on large part on that delay to declare the default of the Jones parties, and they refused to request an extension. And interestingly, as soon as they defaulted and terminated the deal with the Jones parties, they wrote to Vestar and said, hey, we're going to need some extra time on this, so we're going to do it November 1st, 2010, attaches a draft amendment to the agreement to give us until November 1st, 2010. So they did make the request, but just not until after they defaulted the Jones parties for failing to complete construction on time.
During a period when they were in charge of construction.
Correct.
Thank you.
And did the parties, was there a dispute at trial? Who was the actual manager of the project?
I don't believe that there was any dispute that KEG Canada did assume the responsibility to serve as project manager and did undertake that responsibility and was, in fact, managing the project. There were certain things that Will Jones did. For example, when the KEG parties were unable to get the performance bond for whatever reason, they were notified of the need to get a performance bond in April of 2009, I believe it was, but as of November 4th, 2009, they still didn't have it. And so they emailed Will and said, we're not able to get this done. 12 days later, Will got it done. So when they were allowing him help, he was getting the job done, but they were the ones overseeing the management. In addition to that being a breach of the express covenant, we do believe it was a breach of the implied duty to carry out those duties with reasonable care and skill. And KEG Canada wants this court to find that there can be no implied duties in the agency agreement. And we think that's untenable for two reasons. One, they prevailed in the argument that there is no fiduciary duty here, and yet now they're relying on the fiduciary duty to say, wait a second, that's a tort claim. You don't have a contractual remedy. Your remedy is tort. They can't have it both ways. There either is a tort or there isn't. They prevailed on the argument that there isn't a tort because it's a contract-based claim. And we also think the argument is untenable because the notion that a party can mismanage its responsibilities in such a way to cause over $1 million in damages to the party with whom it's contracting, and then say, wait a second, we have no liability because it doesn't expressly state in the agreement that if you are going to undertake to manage construction, you actually have to do so competently. I mean, that's not consistent with logic, it's not consistent with Petyak, it's not consistent with a restatement. We just don't believe that that is what the law is. So we think the verdict should be affirmed on either one of those grounds. The third argument that KEG Canada makes as to its inability to be held liable is that there was insufficient evidence of breach of the implied covenant of good faith and fair dealing. And this argument is not based on KEG Canada's failure to perform any specific extra contractual duties. It is based on the premise that KEG Canada exercised its discretion in such a way to deprive the Jones parties the reasonably expected benefits of their bargain. The evidence presented at trial was that KEG Canada overpaid the contractor, caused the construction delays, as we've discussed, and then relied in large part on that delay to declare default by the Jones parties, induced the Jones parties to unfreeze the escrow account, in the course of a month drained $800,000 from that escrow account, which is over half of the initial balance, and then sent the notice of default the day after the last withdrawal. Sent the notice of default based on defaults that had not actually occurred or for which the only remedy was liquidated damages that the Jones parties were current on paying. Induced the Jones parties to invest over $2.7 million in developing a restaurant, and based on representations that they apparently never intended to honor, and interfered with the Jones parties' efforts to obtain financing. Now, certainly KEG Canada did not have an obligation to assist with the financing, but when it chose to get involved and when it chose to say, yes, we will enter into this tri-party agreement, and when it sent the Jones parties down the path of obtaining financing on that ground, it could not back out at the last minute for bad faith reasons. And during trial, there was testimony as to why KEG Canada changed its mind at the last minute. And KEG Canada's Director of Legal Services stated at least 3 times, well, we didn't trust Will Jones. She also stated separately at least 3 times, we thought he misused the financials and provide them to other misuse.
Misused or would misuse?
Would misuse. We assumed that he would misuse the financials. If we provided our financials to Security National to help with this financing, if that doesn't work out, Mr. Jones will just take those financials and provide them to other banks. We believe he'll do that, notwithstanding the fact that there was a confidentiality provision in the parties' agreements that precluded him from doing so, and that there are other ways to address that concern. We think that the testimony provided at trial provided a sufficient basis for the court to find that the KEG parties did not declare default and did not back out of the financing efforts at the last minute for legitimate business reasons, but because, as in the County of La Paz case, they just decided that they did not want to be in business with Will Jones anymore. And the jury certainly could have concluded that the Jones parties had reasonably expected a fair opportunity to build this restaurant, and that the KEG parties deprived them of that fair opportunity. I have just a minute left. I do want to touch on really briefly the instructions on contract modification. The instruction on contract modification, the KEG Canada argues, was incorrect because it did not instruct the jury as to the effect of a no oral modification clause, but the KEG parties did not ask the court to provide to the jury an instruction that simply addressed the effect of a no oral modification clause. It asked the court to provide an instruction that quoted in their entirety 3 full provisions of the parties' contract. And I think the court properly said, I'm not going to insert facts of the case or argument into a jury instruction, and it was correct for the court to reject that argument. Again, as I mentioned, the jury verdicts followed a 9-day jury trial, and KEG Canada is appealing those verdicts based primarily on the sufficiency of the evidence and arguments that it failed to preserve below, which are more fully set forth in our answering brief. Judge Duncan did not abuse her discretion. The judgment in favor of the Jones party should be affirmed in all respects, and the Jones party should be permitted to file an application for their attorney's fees and costs. Thank you.
Thank you.
Your Honors, I'd like to, of course, answer any questions you have, but also address the issues raised by my opposing counsel. And I'll start with the most recent, that being contract modification. The KEG entities objected to the contract modification instruction being given at all, simply because it was an erroneous instruction of law, considering that we had conflicting contractual language. Whether the trial court included excerpts of the contracts or simply instructed the jury that in this case these contracts prohibited oral modification, either would have been okay. The problem with the instruction given was that it set up a conflict between the 2 points of law we had. In the trial court, TOVK argued that this was something that was just merely factual, it was merely argument, we could deal with it later. But the purpose of a jury instruction is to instruct the jury on the law, and that was not done properly here. So we do continue to have an issue with that. On good faith and fair dealing, something that is, I think, critical to examine here is whether these were, in fact, reasonable expectations of the contracts at issue. What we find time and again in this case is that all of these responsibilities were contractually allocated. TOVK agreed to do a number of things. Certain KEG entities agreed to do a number of things.
Are you saying that for good faith and fair dealing to apply, it can't be part of a specific contractual obligation?
That's correct. If it's been allocated to another party. And in TOVK's brief, they actually cite a case called Kuhn versus Stanley. It's a Division II case. And it was a very interesting case because it dealt with a situation where they were claiming that the defendant breached the covenant of good faith and fair dealing because it didn't provide an appraisal, when in fact the contractual language itself disclaimed the obligation to provide an appraisal. This is very similar when we look at financing or management of constructions, things that were expressly allocated in the contracts to TOVK and no one else. So when they complain to us about mismanagement or they complain to us about not guaranteeing loans for them, those are things that were their responsibility, that they agreed to do, not us.
When you agree to undertake responsibility for the construction, that's something that's contained in the language of a contract, right?
Their agreement to undertake it or ours?
No. When the folks at KEG undertook to take responsibility for the construction, under the circumstances we've talked about at some length, will you agree with me that that can be done in a manner that breaches good faith and fair dealing without necessarily breaching a specific provision of the contract?
It presupposes the existence of a contract, which we can test. Even if there was a contract created under those agency letters, which we've cited the restatement and in Reynard and Trust that show that even if there is an acceptance of an agency appointment or even action as an agent under an appointment or an authorization like this, that doesn't create a contract. There's got to be more. But even if there were, we have to look at that contract and determine what the obligations were. What did we agree to do? There's no agreement on the part of any KEG entity to take on their obligation, to assume their obligation to manage this project and to build it.
So you are disputing that you manage the project. You're saying that TJOK managed the project, although it looks to me like they shoved TJOK away and took over building the restaurant.
TOVK agreed under the development agreement to build it and manage it. They signed 2 agency authorization letters that gave KEG limited responsibility to sign off on work orders subject to their instructions, subject to their budget, and subject to their final approval. KEG could do nothing without their authorization. KEG could do nothing without the scope of their plans. It was ultimately their agreement. It was ultimately their responsibility to build it. So whether we're looking at it under an express violation of the so-called agency contracts or a breach of the good faith and fair dealing covenant, the question is, what was their expectations? If we didn't agree to do it, if we had no obligation to do it, and it was merely, we're the boots on the ground there, so authorize us to sign off on things because you live in another state or in another country, then that's fine, but that's still just an authorization. The question that we were given on liability was even more problematic because not only does it allow a violation of the contract, and I believe counsel had alluded to this, it also opened up fiduciary duty again, which we'd already won. We had argued time at summary judgment that there were no fiduciary duties in this case, and the trial court dismissed those claims. But when we get to the jury charge, it's there again. We objected to...
Wasn't she arguing that you were the one arguing that the fiduciary duty was implicit in whatever it was after you had fought to get that out?
That's incorrect, and we reviewed this, I believe, in our reply brief. We objected to fiduciary duty being submitted at all for the reason I just stated, that it had already been disposed of. They're trying to backdoor it in later because they're trying to shoehorn all of these claims. They lost some of their claims at summary judgment. They lost more of their claims at trial. And so they're left with this really unique set of contract violations, supposed contract violations against KEG Canada. But they've lost all these other claims, and they've lost against these other entities. So they're trying to cram it down to fit the few claims that they actually prevailed on, and it doesn't work. They had the opportunity to appeal those judgments, and they didn't. This is a predicament of their own making. We think the court's got to reverse it.
Thanks, Counsel.
Thank you.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. With that, we're adjourned.